There is a name that the entire internet knows. It does not matter what language you speak, what country you live in, or how closely you follow news and politics. If you have been online in the past several years, you have encountered it. The name is Jeffrey Epstein. And the reason it keeps coming back, the reason it refuses to stay buried the way the people involved in this story clearly wanted it to, is not because of one crime or one arrest or one headline. It is because of what the case represents. It is because of what it confirmed about the relationship between power and accountability in the modern world. And it is because the documents that federal investigators collected when they arrested Epstein in 2019, millions of pages of records, photographs, communications, and evidence seized from his properties were kept from the public for years, until they were not. What happened when those documents began entering the public record changed something fundamental. Not just in how people understand this specific case, but in how people understand the systems they live inside, and the institutions they were told they could trust. That is what this video is about. Not the sensationalism that has surrounded this story from the beginning. Not the theories that multiplied around it, like vines around an old wall, until it became nearly impossible to separate what was documented from what was invented. The actual record, the confirmed facts, the judicial findings, the documented institutional failures, and the honest assessment of what changed when the files entered the public domain, and what, despite everything, did not change at all. Before we go anywhere near the documents themselves, before we talk about what was in them, and what was not, and what people claimed was in them that turned out to be entirely fabricated, we need to establish something clearly, and keep it established throughout everything that follows. The Jeffrey Epstein case is not a theory. It is not speculation constructed from inference and anonymous sources. The foundational facts of this case are documented, adjudicated, and confirmed by federal courts, whose findings exist in the permanent public record. Epstein was arrested in 2019 on federal charges related to the trafficking and exploitation of minors. His associate, Ghislaine Maxwell, was convicted in 2021 by a federal jury on charges including sex trafficking of a minor, and was sentenced to 20 years in federal prison. Those convictions exist. Those facts are not in dispute by any serious analyst or legal authority. The documented record confirms that a network operated over a period of years, that multiple victims provided testimony found credible by federal prosecutors and a federal jury, and that the people at the center of that network are either dead or serving a long federal prison sentence. What remains genuinely worth examining carefully is a different set of questions entirely. How did this operate for as long as it did, without sustained institutional intervention? What does the documented connection between this network and powerful people in finance, politics, and media tell us about how accountability actually functions when resources are sufficient to resist it? And why did the evidence that federal investigators collected take so many years to reach the public record when the people it documented most directly had the most to lose from its release? Those are the questions the documents raise and partially answer. And the answers that exist are in the record itself, not in speculation. If you want to follow stories like this one, with the analytical depth and factual precision that the noise surrounding this case makes extremely difficult to find anywhere else, subscribe to this channel right now and turn on notifications. Every development covered here is grounded in documented record, confirmed court filings, official proceedings, and verified investigative report. No speculation presented as established fact. No unverified claims about individuals who have not been charged with or convicted of anything. That standard matters enormously in a case this significant, because the noise around it is precisely what has allowed the genuine substance of it to be consistently dismissed by people whose interests are served by dismissal. Leave a comment before you keep watching. What do you think the release of these documents actually changed in terms of real public accountability? Because the answer to that question is more complicated, and in some ways more troubling than either the people who celebrated the releases or the people who dismissed them were willing to acknowledge. To understand why the Epstein files became the cultural and political phenomenon they became, why they generated the sustained public attention and demand for disclosure that eventually overcame years of legal resistance, you have to understand where Jeffrey Epstein started. Because the distance between where he began and what he built over the following 4 decades is one of the most revealing things about how systems of institutional power actually function, and who those systems protect when protection becomes necessary. Epstein was not born into wealth or privilege. His mother worked as a school aide. His father was a Parks Department employee. He grew up in Brooklyn in circumstances that were ordinary in every measurable sense. With no inherited advantage, no family connections to the worlds of finance and politics he would eventually inhabit, and no obvious path to the position he would come to occupy. He attended college but did not complete a degree. He obtained a teaching position at the Dalton School in Manhattan, a private institution whose students came from families that represented the highest concentrations of wealth and social connection in the city. That position gave him access to a world that his background had not prepared or entitled him to enter. And access, in the world Epstein was moving through, was the only currency that ultimately mattered for the trajectory his life would take from that point forward. By the mid-1980s, he had left teaching and entered finance, working initially for the investment bank Bear Stearns, before eventually establishing his own financial management operation. By the early 90s, he was managing assets for ultra-high net worth clients, through a structure that operated largely outside the normal frameworks of regulated financial activity, and whose specific operations remained opaque to the public and to most investigators for years. The source of his wealth was a question that financial journalists and federal investigators examined repeatedly, without producing a fully satisfying account. What the public record establishes is that the wealth was real, that it was substantial, and that it funded a lifestyle and a network of social connections that extended far beyond what any conventional financial management operation of the scale he described could reasonably have supported. By the late 90s, he had accumulated properties in Manhattan, Palm Beach, New Mexico, the Virgin Islands, and Paris. He maintained a private aircraft. He had documented relationships, confirmed through court filings, flight logs, and investigative reporting, with individuals whose influence extended across some of the most significant institutions of the late 20th and early 21st centuries. How a person makes that specific journey from an ordinary background in Brooklyn to the center of a documented international network with confirmed connections to heads of state, former presidents, Nobel laureates, and the most prominent figures in technology and finance is one of the central questions the documented record raises. It is also one of the questions the record does not fully answer. What the public record does establish is that the ascent involved financial acumen, a systematic approach to social networking that investigators describe as deliberate rather than incidental, and a mechanism of influence that appears to have been constructed and maintained over many years with a specific operational purpose. The mechanism is what distinguishes this case from a straightforward story of financial crime or abuse of power. Investigators who reviewed materials seized from Epstein's properties found documentation, suggesting that information was collected and retained in ways that served purposes well beyond ordinary personal record-keeping. The picture that emerged from the federal investigation and from the civil proceedings that followed over years of litigation is of a network whose operations were not passive or accidental. The documented record supports the conclusion that what Epstein built was constructed deliberately and maintained. How that network maintained the access and protection it demonstrably enjoyed for as long as it did is the question that the document releases brought into sharper focus without providing a complete answer. It is also the question whose honest examination requires the most careful attention to what is confirmed versus what is inferred, because the gap between those two categories in this case has been exploited repeatedly by people with no interest in accuracy and every interest in generating attention. 2008 is the year that honest analysis of this case has to spend significant time examining, because what happened in 2008 is essential to understanding everything that followed, including why the files became the subject of the sustained public demand that eventually produced their release into the public record over a decade later. In 2008, federal prosecutors in the Southern District of Florida reached a non-prosecution agreement with Epstein that resulted in him pleading guilty to 2 state charges rather than facing the federal prosecution that the evidence available at the time could have supported. He served 13 months of an 18-month sentence at a Palm Beach correctional facility and was permitted to leave that facility 6 days a week under what was described as work release, which allowed him to spend significant portions of each day at his Palm Beach office. The contrast between the sentence that arrangement produced and the severity of the conduct that federal investigators had documented was stark enough that it generated immediate questions from victims and their legal representatives about how the outcome had been reached and whose interests it had been designed to serve. The lead federal prosecutor who negotiated the non-prosecution agreement was Alexander Acosta, who at the time served as the United States Attorney for the Southern District of Florida. Acosta later served as Secretary of Labor in the Trump administration. From 2017 to 2019, he resigned from that cabinet position in July of 2019. The same month, Epstein was arrested for the second time on federal charges, when detailed reporting about the terms of the 2008 agreement renewed congressional scrutiny and public attention to how that outcome had been reached and whether it had been appropriate given the evidence available at the time. When asked about the agreement during his tenure as Labor Secretary, Acosta stated that he had been told that Epstein was an intelligence asset and to leave it alone. That statement was made in the context of a meeting with White House officials discussing his future in the administration. It has never been officially confirmed or denied by any intelligence agency. It exists in the public record as a reported account of what Acosta said, not as a confirmed fact about Epstein's relationship to any intelligence operation. It is included here because it is part of the documented public record of what was said about this case by people with direct involvement in it. The victims in the 2008 case were not consulted before the agreement was finalized. They were not informed of its terms in advance. They learned of the outcome after it had been concluded. A federal judge later ruled that their rights under the Crime Victims' Rights Act had been violated by the manner in which the agreement was handled. Those are documented findings from federal judicial proceeding. The gap between what the federal evidence in 2008 supported in terms of potential charges and what actually resulted from the negotiated agreement is a documented gap that exists in the permanent public record. It is one of the foundational documented failures of this case, and it established a precedent of institutional accommodation that shaped public understanding of how this case was being handled by the systems whose job it was to produce accountability. When Epstein was arrested again in July of 2019, the federal charges were substantially more serious than what the 2008 state charges had described. The indictment alleged a criminal conspiracy to exploit minors that had operated across his properties over a period of more than a decade. Federal agents executed search warrants at his Manhattan residence and recovered substantial quantities of evidence, including documents, communications, financial records, and digital materials. That evidence became the foundation of a federal case that was building toward trial, and that, given the scope of the indictment and the evidence described in the supporting documentation, represented the most serious legal challenge Epstein had ever faced. It never reached trial. In August of 2019, approximately 1 month after his arrest, Epstein was found dead in his cell at the Metropolitan Correctional Center in New York. The medical examiner ruled the death a suicide. The documented circumstances surrounding that ruling, including confirmed failures in the monitoring protocols that were supposed to be in place for a high-profile defendant facing serious federal charges, generated immediate and sustained public skepticism. Camera systems covering the relevant area of the facility experienced documented technical failures. Staff members who were required by protocol to conduct checks at regular intervals did not do so within the documented timeline. 2 facility employees were subsequently charged with falsifying records related to their conduct during the relevant period. Both employees ultimately entered deferred prosecution agreements and did not serve prison time. The documented failures in the custodial oversight of Epstein are confirmed facts. What caused those failures, and specifically, whether they resulted from negligence, institutional dysfunction, or deliberate action, is a question the public record does not resolve. What it does establish unambiguously is that the institutional system responsible for ensuring this case reached trial failed to fulfill that function in documented ways, serious enough to produce federal criminal charges against facility staff. Ghislaine Maxwell's trial in federal court in New York in late 2021 produced the most significant judicial accountability the Epstein case generated. The trial established through victim testimony and documentary evidence that the network had operated systematically, that recruitment and exploitation had occurred across multiple properties in multiple jurisdictions over a sustained period, and that Maxwell had played an active and central role in those operations that went far beyond passive association with Epstein. The jury found her guilty on 5 of 6 counts after deliberating for 6 days. She was sentenced to 20 years in federal prison and is currently serving that sentence. Her conviction is the judicial anchor of the public record on this case. It establishes, at the level of confirmed legal fact, that what multiple victims described occurred, that there was an identified individual with documented criminal responsibility beyond Epstein himself, and that the federal judicial system was ultimately capable of producing a conviction in this case, even after the circumstances of Epstein's death had raised serious questions about whether full accountability would ever be achieved. During pre-trial proceedings in the Maxwell case, and in connected civil litigation, court-ordered document releases began making portions of the investigative and civil record available to the public. Those releases occurred over a period of years, were contested repeatedly by parties seeking to keep specific materials sealed, and produced ongoing public debate about what the documents showed and what they meant. Among the public figures whose names appear in court documents released through those proceedings, former President Bill Clinton's documented travel on aircraft associated with Epstein is a confirmed matter of public record, acknowledged by his office, with the stated explanation that the travel predated public knowledge of Epstein's criminal conduct. Prince Andrew, the Duke of York, was the subject of a civil lawsuit filed by a victim who alleged specific conduct involving him. That lawsuit was settled in 2022 for an undisclosed financial amount, with no admission of liability by Prince Andrew, who subsequently stepped back from public royal duties in the context of that case. Bill Gates, whose documented interactions with Epstein consisted primarily of meetings that Gates subsequently acknowledged publicly, described those meetings as a professional error that he regretted. These documented facts about named public figures are included here because they are part of the confirmed public record and because honest analysis of what the files revealed requires engaging with what is actually confirmed, rather than with the far more extensive claims that circulated online without documentary support. What the public record shows about each of these individuals is specifically and materially different from what significant portions of the online conversation about this case suggested. That distinction between documented fact and unverified claim is not a minor technical point. It is the difference between accountability and noise. And in this case, the noise has consistently functioned to protect the people whose documented conduct deserved the most scrutiny, by making the entire subject easier to dismiss as the province of unreliable sources. One of the most significant documented effects of the Epstein files on the broader information environment was what it revealed about how misinformation propagates through systems where institutional trust has already been severely damaged. The release of real and confirmed materials was accompanied almost immediately by the circulation of fabricated or deliberately misattributed content. Images were created or altered to associate individuals with the case who had no documented connection to it whatsoever. Claims circulated as confirmed fact that existed nowhere in the actual documentary record, and could not be traced to any verified source. The inability of a significant portion of the public to distinguish between confirmed, documentary evidence and fabricated material did not happen by accident. It reflected both the genuine depth of public distrust of institutions that had demonstrably failed to produce accountability for years, and the deliberate exploitation of that distrust by people with no interest in accuracy and every interest in generating engagement. The result was a public conversation in which the genuine and documented institutional failures of this case, which are serious and deserve sustained analytical attention, were consistently obscured by a parallel conversation about unverified claims. People with documented connections that were genuinely significant were discussed alongside people whose connection was entirely invented, and the noise made the documented signal harder to identify, analyze, and act on in any way that might produce real structural accountability. The documented institutional failures in this case operate at several distinct levels that deserve separate examination. The 2008 non-prosecution agreement represents a failure of the prosecutorial process, in which the outcome was demonstrably inconsistent with the available evidence, and in which the statutory rights of victims were violated in a manner confirmed by federal judicial finding. The monitoring failures at the Metropolitan Correctional Center in 2019 represent a failure of custodial oversight, whose full causes were never publicly established. The years-long delay in making investigation materials available through court proceedings represents a failure of transparency that the judicial system eventually partially corrected only after sustained legal pressure. and the documented social ecosystem that surrounded Epstein's operations for years, in which his activities were either unknown to or tolerated by many individuals with the standing to have raised concerns, represents a failure of informal accountability that the record establishes without explaining. Legal analysts and former federal officials who have commented on what this case represents as a matter of systemic analysis have consistently identified the same structural features: the relationship between extreme wealth and legal outcomes, the insulation that institutional prestige provides from scrutiny, the tendency of institutions to prioritize their own functioning and reputational protection in ways that conflict with the accountability they nominally exist to produce. What the Epstein case provided was a specific, confirmed, high-profile example of all of these dynamics operating simultaneously and visibly, enough that they could not be entirely explained away. Where does the documented public record leave us? Epstein is dead. Maxwell is serving a 20-year federal sentence. The network was real and confirmed by federal judicial findings. The victims whose testimony established that record went through years of legal proceedings to have their experiences acknowledged. Several have spoken publicly about what that process cost them and what accountability ultimately looked like from where they stood. Some have said the partial accountability achieved was better than nothing, but fundamentally incomplete. Some have noted that the people most directly responsible are either dead or convicted, while the broader structural conditions that enabled this to operate without sustained intervention have not been addressed through any documented reform. Those assessments from the people who were actually harmed deserve to anchor any honest analysis of what the files changed and what they did not. What demonstrably changed is measurable. Public awareness of how institutional systems protect documented criminal conduct when sufficient financial and social capital is involved is substantially higher than before this case entered the sustained public conversation. The legal mechanisms through which victims can fight for documentary access have been tested and in some respects strengthened through these proceedings, and the documented record of what happened exists now in a form that cannot be removed from the public domain. What did not change is equally measurable. The structural conditions that made this possible have not been addressed through documented institutional reform. The Epstein files changed what the public knows. They did not change how the systems that protected this for years actually function. That gap between documented knowledge and structural change is the most important thing the record of this case leaves unresolved. Subscribe to this channel and turn on notifications. The next video in this series examines the specific documented mechanisms through which this network built and maintained its access to institutional power, because understanding precisely how it worked is the necessary foundation for any honest assessment of whether anything meaningful has actually changed to prevent the next version of it.